Welcome friends, I welcome you all at Swayam platform. Now today I am going to conclude the week third and the last topic of this week is registration of Hindu marriage. Friends, before starting this lecture I want to summarize the lecture what I discussed in the last class. In the last class we discussed about the condition of marriage, about the marriageable age, private degree relationship. We also discuss about the Sapinda relationship and we also discuss about the ceremonies and customary rights related with marriage. Friends, in the last class we understand that now the age of marriage is fixed, 18 year for bride, 21 year for the bridegroom. The very important point is private degree relationship and Sapinda relationship. Hindu law provides a fundamental rule. This is known as rule of exogamy. Marriage within the close relatives are prohibited under Hindu law. Question is why prohibited? Prohibited because if you marry within the close relatives, certain physiological reasons may emerge and certain psychological reasons, sociological reason and idea of morality may also hurt your marriage. Therefore, Hindu law prohibits marriage within close relation. Friends, what happened nowadays in Pakistan, the number of report reflected that when they marry within the close relatives, certain physiological diseases emerged among them. Therefore, Hindu law prohibited them. Therefore, we have a private degree relationship and Sapinda relationship, and performance of section 7 related conditions is also very crucial for the marriage. Friends, so now after the marriage and after the completion of marriage, after the completion of the condition of marriage, it is important to explain that the process of registration of marriage and the requirement of marriage. Friends, now the point is what is the learning objectives of the today's class? The learning objective includes the meaning of the registration of Hindu marriage and steps of registration and the consequence of non-registration of Hindu marriage. These are the three learning objectives through which we are going to discuss about the discussion. Friends, registration of marriage means officially recording a marriage in a government's records. Simple meaning, officially recording a marriage in a government's record. The Article 3 of the Convention on Consent to Marriage, Minimum Age for Marriage and Registration of Marriage 1962 states that all marriage shall be registered in an appropriate official register by the competent authority. Friends, Article 16 subclass 2 of the Convention on the Elimination of All Form of Discrimination Against Women, CEDAW 1979 provides that the state party shall take necessary steps to make the registration of marriage is an official registry compulsory. So, CEDAW for the purpose of protecting the interest of women want compulsory marriage registration. Friends, but India ratified this CEDAW, with a reservation on compulsory registration of marriage. Therefore, in India, marriage registration is not compulsory. Friends, now I want to focus on the registration of marriage. Although India agreed on principle that compulsory registration of marriage is highly desirable, but reservation is that it is not practical in a vast country like India with its variety of custom, religious and the level of literacy, and has expressed reservation to this view, to this very class, to make registration of marriage compulsory. Friends, traditionally registration of marriage is not required under Hindu law because Deret in his book Introduction of Modern Hindu Law pointed out that generally Hindu do not get their marriage registered, unlike adoption, will, transfer of property and partition. The Hindu interested to register will, register partition, everything, but Hindu not register interested in registration of Hindu marriage. Friends, in a case of Kamalkant Chiba, the Bombay High Court held that there was no requirement for registration of Hindu marriage before the Hindu Marriage Act 1955. Friends, now I want to focus on the benefits of the registration, friends. Friends, first and important benefits of the registration is for the purpose of facilitating the proof of marriage. The registration cannot affect the validity of marriage. Registration may be useful only for the purpose of facilitating the proof of Hindu marriage. Friends, to restrict the practice of bigamy and polygamy, registration also play a very crucial role. Friends, it also enables widows to exercise the inheritance rights and claim for other benefits under the Act. Friends, it also prohibits the practices of child marriage, because when you are going to registration, you may be prohibited for that. The government can gather accurate data on the registration of marriage to frame effective policies on women empowerment, family planning and other social welfare program. Therefore, registration is also useful. Friends, data on registration of marriage can help in promoting the health, education and other requirements of the vulnerable community, and therefore it is required. These are the purpose and benefit of the registration. Therefore, scholars are good for the registration of a marriage. Friends, I want to focus on the section 8, which deals with the registration provisions of Hindu marriage. Section 8 provides that for the purpose of facilitating the proof of Hindu marriage, the state governments may make rules providing that the parties to any such marriage may have the particulars relating to their marriage entered in such manner and subject to such condition as may be prescribed in Hindu marriage register kept for the purpose. Friends, now section 8 rule 1, section 8 subclass 1 is very clear. The Hindu Marriage Act 1955 does not contain the rule for the registration of marriage. State governments have been authorized to develop a rule and develop a mechanism and register the marriage. Friends, therefore section 8 empowers state governments to formulate the rule relating to the registration of marriage between two Hindus, man and woman. Friends, therefore the UP cabinet also approved the registration rule of marriage in the year 2017. I will discuss some aspects of rules on registration, friends. And friends, if you think about the practices related in the domain of families, Hindu have two different kind of option. One is they may marry as per the customary rites and ceremony of either party. There too they may register their marriage under the Hindu Marriage Act. They may marry as per the Special Marriage Act. They may contract a marriage under the Special Marriage Act. Then they register their marriage under the Special Marriage Act. Means Hindu is not bound to perform the marriage under the Hindu Marriage Act. Hindu may select the path of Special Marriage Act, may register the marriage under the Special Marriage Act if they are not interested to undergo the customary rites and ceremonies for the performance of marriage. Friends, now I want to focus on section 8 subclass 4, which is clear that Hindu marriage registrar shall at all reasonable time, the Hindu marriage register shall at all reasonable time be open for inspection and shall be admissible as evidence of statement therein contained, and certificate extracts therefrom shall on the application be given by the registrar on the payment to him of the prescribed fees. Therefore, the marriage register is admissible as an evidence to prove the existence of marriage. Friends, I want to clarify a philosophical and practical point. The point is, marriage is one thing, registration of marriage is another thing. The rule is very clear registration of marriage may facilitate the proof of marriage, but whether your marriage is void or voidable or valid, it is different question. Registration certificate may facilitate your argument, but registration certificate is not conclusive proof about the validity of marriage. Therefore, validity of marriage cannot be affected by the registration. Therefore, we must understand the validity of the marriage one hand and registration and usability of registration on another hand. Friends, now I want to focus on the case Dali Rani versus Manish Kumar Chanchal case. This is a very interesting case decided by Supreme Court in the year 2024. Friends, the idea is very clear that both are pilots. They enter into the marriage, they obtained certificate from a registered society and they registered their marriage under the Uttar Pradesh marriage registration rule 2017. Friends, the point is they not performed marital ceremonies. They obtained certificate by hook or crook, and by utilizing the certificate they registered their marriage. But due course of time they started fighting, and finally this matters came before the Supreme Court, where both the parties of so-called marriage jointly file a petition before Supreme Court to declare the marriage null and void because they not perform the marriage as per the religious rites and ceremony. Friends, now be careful about the fact of Dali Rani case, friends. They not married as per Hindu rites. They managed certificate from a registered society, and on the basis of certificate they obtained registration certificate. But Supreme Court clearly observed in this case and held that in the absence of there being a valid Hindu marriage, the marriage registration officer cannot register such marriage under the provision of section 8 of the Act. Therefore, if a certificate is issued stating that the couple had undergo the marriage, and if the marriage ceremony had not been performed in accordance with the section 7 of the Act, then registration of such marriage under section 8 would not confer any legitimacy to such marriage. So this is the point, friends, which should be considered by any person. Means certificate is one thing, validity of marriage is another thing. If you obtain certificate from any samiti or society and you register your marriage on the basis of the certificate, it not confer you status of husband and wife unless you married properly as per the Hindu law. So this is the Dali Rani case, is a classical recent example where Supreme Court held that marriage is not an event of dance, not an event for taking and giving the dowry. If you not perform the religious ceremony, registration will not protect your interest, registration will not provide you a status of married people. In a case of Sudhir Mohan Sethi, the Kerala High Court also observed that it cannot be claimed that a divorce cannot be decreed when the spouse has not sought cancellation of the certification. So cancellation of certificate of registration is one thing, divorce is another thing. What is the argument is? The argument is very clear. A person want to divorce. The court argued that divorce may be granted whether your marriage is registered or not registered. It is not required to you, first you cancel your certificate, then you approach for divorce. This is two different things. Therefore, so long as certificate exists, marriage may also be dissolved by court as per the provision of Hindu Marriage Act, friends. Friends, now I want to focus on the registration of marriage under the Special Marriage Act. Special Marriage Act section 15 talks about the registration of marriage under the Special Marriage Act. Friends, why I am stressing the Special Marriage Act? Because Hindu may also marry under the Special Marriage Act, may also register their marriage under the Special Marriage Act. There is no such kind of prohibition. The rule is very clear and simple that if you perform your marriage as per the customary rites and ceremony which is prescribed under Hindu law, then your marriage may be registered under section 8 of Hindu Marriage Act. But if you are not performing, you just enter into a contract, then you may go select the path of Special Marriage Act and register your marriage under section 15 of the Special Marriage Act. And therefore, Special Marriage Act provides that your marriage may be registered in a certain circumstances if ceremony of marriage has been performed between the parties and they have been living together as a husband and wife ever since. Neither party has at the time of registration more than one spouse living. See, neither party is an idiot or lunatic at the time of registration. D. The party have completed the age of 21 years at the time of registration and the parties are not within the degree of prohibited relationship. So, these are the criteria. On that basis your registration, marriage of registration is possible under the Special Marriage Act. Friends, now we can analyze the provision of section 15. The effect of registration under section 15 is stated in section 18, and section 18 states that where a certificate of marriage has been finally entered in the marriage certificate book, the marriage shall, as from the date of such entry, be deemed to be a marriage solemnized under this act. This line is very crucial, friends. When you register your marriage under this act, means you will govern as per the Special Marriage Act. Friends, by the amendment in the Special Marriage Act, it is now provided that if you register your marriage under the special marriage, if you are Hindu, both the parties are Hindu, then succession may also apply Hindu Succession Act. Primarily it was excluded, but now the rule is simple and clear. After the marriage under the Special Marriage Act, if you are Hindu, Buddha, Jain and Sikh, in the circumstances Hindu law of succession will apply in your case. This is the rule laid down under section 21 capital A. Friends, all the children born after the date of ceremony of marriage whose name shall be entered into the marriage certificate books shall in all the respect be deemed to be and always to have been legitimate children of their parents. Friends, now I want to focus on the effect of non-registration. According to section 8 subclass 5 of the Hindu Marriage Act 1955, notwithstanding anything contained in section 8, the validity of any Hindu marriage shall in no way be affected by this omission to make the entry. Means, friends, as per section 8 subclass 5, the validity of marriage is one thing, registration is another thing. If any kind of omission is there, it not mean that validity of marriage is questioned. Friends, therefore marriage shall be valid even in the case of non-registration of marriage. Friends, be careful when we think about the registration and the idea of registration. Friends, as per section 8 subclass 2, the state governments may make the compulsory provisions for the registration of marriage, and section 8 subclass 2 further states that person who contravenes the provisions shall be punishable with the fine 25 rupees of fine. Means, friends, registration is prescriptive, it is not penal. Legislature want to prescribe and want to create a norm by which people should encourage towards the registration of marriage. Therefore, a nominal punishment is there just to create a norm for the purpose of registration. Friends, the idea of registration was detailed discussed by Honorable Supreme Court in very famous case Seema versus Ashwani Kumar, AIR 2006, Supreme Court, page number 11582. The Supreme Court held that registration of marriage of the Indian citizen belonging to all religion should be made compulsory in all state. So, this is the outcome of the Seema versus Ashwani Kumar case. And further court observed that it has been pointed out that compulsory registration of marriage would be a step in the right direction for preventing the child marriage and shall prevent is still prevalent many part of the country. Further, the court observed that it has been pointed out that customary registration of marriage would be a step in the right direction for the prevention of child marriage is still prevalent in many part of the country. Friends, as per the direction of the Seema versus Ashwani Kumar, the Uttar Pradesh government enacted Uttar Pradesh Marriage Registration Rule 2017. This rule was approved by the cabinet on the 1st August 2017 and finally after the publication in Gazette and the assent of the governor, it in force from 3rd August 2017. This rule clearly mentioned that in Uttar Pradesh compulsory registration is required, means any person, either Muslim, either Christian or Hindu, bound to register their marriage under this rule. And section 6 is very particular about that and provides that registration of marriage irrespective of religion is mandatory in Uttar Pradesh, friends. And rule 13 also laid down the rule that to obtain the benefit of government scheme where the information of marital status is required, registration number of marriage is mandatory. Means the government indirectly link the benefit of government scheme with the registration number of the marriage. Friends, in this rule, Uttar Pradesh government also clearly mentioned that no way registration certificate affect the validity of marriage. Validity is one thing and registration is another thing. But rule also creating a norm, you may register your marriage. Friends, you may register your marriage by this rule and this rule is effective, which is also applied all over the persons residing in the territory of Uttar Pradesh, friends. Think about that, friends. Is it possible to complete the registration of marriage in a vast and diverse country like India? And the second is, how does the registration of marriage can improve the status of women and how it can prevent the child marriage? You may think and collect the answer by your reasoning. Friends, therefore I want to summarize my today's lecture. The rule is registration of marriage provisions related mentioned in provided under section 8 of Hindu Marriage Act. Registration is one thing, validity of marriage is another thing. Who register your marriage? State governments may register your marriage by making the rules. Rule is not laid down by the central governments. State governments have immunity to make rule and also declare marriage registration as a compulsory requirement. And therefore, Uttar Pradesh government by the direction of Supreme Court as well as the in drawing the insight from section 8 declares compulsory registration of marriage for all communities residing in Uttar Pradesh. Friends, register will be considered as public document, therefore any person may inspect the register, may take copy from the register and what is mentioned in the register shall also be recognized as a evidence admissible in any court proceeding, friends. So this is section 8 which talks about the registration of marriage. Friends, but very interesting fact is because Hindu recognize Hindu marriage as a dharma, as a sacrament, as a purusharth, therefore they are not willing to register their marriage because registration of marriage is totally irrelevant, insignificant among the people's mindset because they recognize the status of marriage is more than and beyond the registration. They not think that marriage is a legal union and it should be formalized. They recognize marriage and its soul and therefore still many people in India not encouraged towards registration. Generally, what we think that registration only possible where the people is going outside the territory of India for the purpose of passports, for taking the advantage of government scheme. In that context only they allowed and prescribed the registration, they preferred registration, otherwise no one is interested in registration by any direction. So friends, this is all about the registration and by this discussion I completed my week 3 lectures where we discuss about the nature of Hindu marriage, condition related with Hindu marriage and registration of Hindu marriage. Friends, Hindu have two options, either entered or ceremonize the marriage as per Hindu Marriage Act, either ceremonize the marriage under the Special Marriage Act. If you interested to marry under the Hindu Marriage Act, you are bound to perform the customary rites and ceremony which is prescribed under section 7. It is mandatory in nature, friends. Therefore, in Dali Rani Sheikh, finally Supreme Court concluded that mere certificate cannot provide validity of marriage unless you not celebrated your marriage. This is the point which may be discussed and explained to develop the idea about the marriage, nature of marriage and registration of marriage. Thank you everyone for your patience. Thank you.